Hey there, and welcome to this explainer. If you're a first-year law student or honestly just someone trying to figure out exactly when you take on the financial risk when buying something, you are absolutely in the right place. Today, we're acting as your targeted study guide. We're going to demystify a totally crucial concept in business law. Basically, who takes the financial hit when goods are destroyed during a sale?
Okay, let's take a quick look at our agenda for today. We're covering the risk of loss, the general rule of risk, exceptions, delayed delivery, and finally, sale versus agreement to sell. Let's get into it.
Section 1. The risk of loss. Who pays when disaster strikes?
So let's start with a hypothetical disaster, just to understand why this area of law is literally so important for both businesses and everyday consumers. Imagine person A makes a contract to sell some goods to person B. Ownership immediately transfers to B. But here's the catch. B hasn't paid the money yet, and they haven't actually picked up the goods from A's godown or, warehouse. Suddenly, unfortunately, a massive fire rips through the godown and the whole batch of goods is burnt to ashes. So who pays for this disaster?
While the key to solving our go-down farter mystery is completely separating the idea of physical possession from legal ownership. The law makes it super clear that possession simply means having physical control of the goods, but property in goods, that means having the actual legal title, the ownership. And honestly, that distinction makes all the difference in the world.
Moving right along to Section 2, the general rule of risk, the baseline legal standard. Now that we've kind of set the stage, let's introduce our core legal rule. In the legal world, we rely on this fundamental Latin maxim, res perit domino. Sounds fancy, right? But translated simply, it just means risk follows ownership. The legal owner of the goods bears the loss, completely regardless of who happens to have physical possession of them when disaster strikes. So let's jump back to our go-down fire. Because ownership had already transferred over to the buyer, B, it is legally held that B is bound to pay A for the loss of the goods destroyed by the fire. Yep, B has to pay the full price of the goods, even though they never actually touched them. Why? Because physical possession is completely immaterial to the risk. Whoever legally owns it pays for it, period. To really lock this in, let's quickly look at Section 20 of the Sale of Goods Act. This section deals specifically with specific goods that are in a deliverable state. Let's use a super clear example. Picture yourself buying a new, fully serviced Maruti car. According to Section 20, ownership passes immediately the moment that unconditional contract is made. The risk transfers the exact second you sign that contract, even if you actually pay for it or drive the car off the lot days or weeks later. You own it, you risk it. All right, Section 3, exceptions, agreements, and customs. When the general rule bends. Because as any law student knows, the law is just full of nuances, isn't it? While risk follows ownership is our solid baseline, there are three main exceptions we need to study where that standard gets tossed right out the window. They are special agreements, trade usage, and delayed delivery. Let's break these down one by one. First up, Exception 1, a special agreement. This is exactly what it sounds like. It's when the buyer and seller explicitly write up a contract where the risk transfers on a totally different timeline than the actual title or ownership. They basically agree to split the two concepts up. For example, imagine a huge shipment of ice cream is heading from Hyderabad to Vijayawada. The seller might stipulate a special agreement where the buyer takes on the risk of the ice cream melting the very moment it's loaded onto the transport lorry. But the official title, the legal ownership, doesn't pass to the buyer until their payment actually clears the bank. Moving on, we have Exception 2, trade usage. Basically, this means that the standard, universally accepted customs of a specific trade or industry can actually override that general legal baseline we just talked about. A perfect classic example of trade usage is an auction. Industry custom dictates that the highest bidder bears the risk of loss the absolute second the auctioneer's hammer falls. Bam! So, if the item breaks right after that moment, the bidder is completely on the hook, despite not legally owning the item until they actually walk over to the cashier and pay the price. Okay, Section 4, the delayed delivery exception, the cost of being late. This exception completely revolves around someone making a mistake. Specifically, Section 26 of the Sale of Goods Act deals with situations where delivery is delayed due to the fault of either the buyer or the seller. The crucial point here is incredibly straightforward. Whoever caused the delay must bear the risk for any loss that occurs because of that delay. It completely overrides the ownership rule just to penalize the party who was at fault. Consider the famous case of Debbie Hamilton & Co. versus Burden. We can lovingly call this the case of the putrid apple juice. In this scenario, a buyer delayed taking delivery of a massive batch of apple juice. And because of this delay, the juice went entirely putrid and spoiled while it was still just sitting there in the seller's physical possession. Now, even though the seller still had physical possession of the juice, the court ruled the buyer had to bear the financial loss. Why? Because the buyer's delay directly caused the spoilage. It is a textbook illustration of Section 26 in action. The party at fault takes the financial hit, no questions asked.
Finally, Section 5, Sale versus Agreement to Sell, Timing the Transfer. Let's quickly contrast these two specific types of contracts to see exactly when this crucial transfer happens. In an executed contract, which is known as a sale, title transfers immediately from the seller to the buyer. This means the risk of loss falls entirely on the buyer right away. But in an executory contract, known as an agreement to sell, the title only transfers at a future date once certain conditions are met. Therefore, the risk of loss remains safely with the seller until that future date actually arrives.
So as you continue to study these concepts in business law, remember the golden rule. Physical possession is definitely not 9/10 of the law here. Understanding exactly when ownership and risk transfer is what truly matters, whether you're taking a law exam or, honestly, just buying a car. Knowing when the risk passes could literally save you from paying for ashes. So think about your next big purchase. Are you absolutely sure when you officially become the owner? Keep that in mind. Thank you so much for joining me on this explainer, and keep learning.